I'm going to ask if Professor Rubenstein can start us off today, and if, because I know that she's written extensively on these questions and has recently appeared before the Senate, the Joint House Committee on Intelligence and Security on related matters. So, and specifically, Professor, if I could ask you this, you're at the just for your introduction, for those who aren't familiar with your work, you're actually at the ANU, and oh, well.
I should give credence to the University of Canberra for poaching me from the ANU.
Well, that is extraordinary.
And I'm a professor at the law school, but I'm also now the co-director of the 50/50 by 2030 Foundation.
Well, there we go. We've got news, breaking news here.
Thank you for the opportunity to announce it.
No, well, Professor is a leading constitutional expert and leading expert on citizenship issues. So I'd ask you, Professor, if you could comment on the article that appears this morning and where the Minister for Home Affairs is quoted as saying that the High Court's recent decision amounted to the court creating a new class of person. And I'm wondering, do you agree with that proposition? Or is it simply that the High Court has reaffirmed the unique connection of Australia's First Peoples have to the land and the waters of Australia?
Thank you, Senator Carr, and thank you to the committee for giving us the opportunity as a collective to contribute to this really important discussion. As academics committed and passionate about the work that we do, that we transmit to our students, it's also fundamental, I believe, for us to have the opportunity to contribute to public policy. That's a significant role of the academic in society, and a committee like this and a reference like this is really welcomed, and we hope, I think I can speak on all of us, that we can contribute to the development of public policy in this area. Those of you who would have seen my Canberra Times piece the day after the judgment will perhaps remember my final paragraph, which says that whether this judgment is honoured by the Parliament and whether the executive seeks to go back to the drawing board to see if there are other heads of power that they can rely on to remove non-alien, non-citizens, because that is something that Justice Stephen Gageler did raise in his argument as a concern about the approach of the plaintiffs, in my view, will reflect on the moral compass of the Parliament as it confronts what I do believe the majority judgment is saying is a deeper truth in relation to the status of Indigenous Australians as belongers, the fullest members of the Australian community. I would not characterise it as a new status, rather it's the court affirming the original status of Indigenous Australians at the time of Federation, because what the court is doing is essentially looking at the constitutional document to determine membership. Who are the core members of the Australian community that the Constitution is responsible for? And of course, as constitutional teachers around the room, one of the first things we teach our students is that constitutions are there to restrain absolute power. It's about putting limits on the powers of Parliament in relation to the way it governs its people. And in determining the people, one of the absences in our constitutional document is a definition of who are members. The convention drafters decided not to have a head of citizenship. So we have never had a clear statement of membership of the Australian community in the Constitution itself, and it's been left to the court to interpret membership through the aliens and naturalisation power. So I would say that, in fact, we have never had clear categories of people who are recognised as full members, and what we have seen from the court in a majority decision is an affirmation of what both Justice Edelman and Gordon refer to as that deep truth that this decision reflects, which is the continuing and non-revocable membership of Indigenous Australians.
Well, I'll just follow that up, because in your submission, this is submission number 42, you're suggesting that there's the capacity to strip dual citizens of Australian citizenship is undermining national unity.
Yes.
and creates a second-class citizenship. You suggested that that those types of laws effectively make some people more vulnerable. Do you, and to paraphrase Mr. Dutton, do you think there is a new class of citizen that's actually been created through those types of laws, and is there a problem in that?
So I have written and argued of my concern right from the start with the amendment to the Citizenship Act to identify one class of citizens, that is dual citizens, to be treated differently to single citizens. So there are many of us in the room who have made submissions in relation to the amendments to that Act, concerned about that categorisation of a new class of membership, because citizenship as a constitutional term has never been this decision is one that helps us identify that the parameters of constitutional membership, but the actual status of citizen, and as many of you in the room will know, only started in 1949, and even at that time, Indigenous Australians who were formerly citizens were treated differently to other citizens. So the notion of the executive being able to treat different members of the community differentially, unfortunately, has a long and difficult history in terms of coming to terms with the use of executive power. And if anything, that's right, dual citizens at the moment in Australia are treated differently and are more vulnerable to the loss of their Australian citizenship than sole Australian citizens. So that does affirm a recognition of what the Minister is saying, is that we are in a scenario which I would argue is anathema to social cohesion, of differentiating rights that flow from citizenship. And if anything, the High Court's decision is saying that there are some boundaries beyond which the executive cannot pass. And so even though this report indicates that they are looking at other heads of power as a possibility for relying on to remove non-statutory citizens who are Indigenous full members of the Australian community, there would still be a question mark as to whether the High Court would say that there is an inherent restriction on the use of those powers to remove the people of the Commonwealth who the High Court has affirmed have this ongoing connection.
Can I ask a question arising from that, please, Chair? What you have quite eloquently characterised as a decision that's affirming what I think the words you used were a deep truth about Aboriginality would be characterised by others as the creation of a new category of understanding who was Australian. So even if I accept for a moment the premise that it's just a recognition of something that always was, it's at least the creation of a new way of understanding that relationship to Australia. That category, I suppose, is people who are not aliens, yes, but who are not citizens either.
Yes.
There is, I'd suggest, a compelling argument that it is harmful to social cohesion to create different categories of understanding what it means to be Australian in circumstances where all other policy is directed towards helping Indigenous Australians, reap all the advantages in a living standard sense of being equal and the same as all other Australians. How would you deal with that argument?
Yeah, I think it's a really interesting one, and it's obviously the source of contention in public discussion. First of all, just for historical purposes, it's not the first time that we find the High Court identifying non-citizen, non-aliens. There was a brief period in our evolution of High Court decisions where British subjects who had lived in Australia for all of their lives but who had not formally become Australian citizens were seen as protected as non-citizen, non-aliens. But then the High Court chose to overrule that decision in relation to British subjects. And I think British subjects are a really good example of the fact that we've always had a differentiated notion of membership, and I will directly answer your point in a moment, but the history is really important in understanding this sort of evolution of this current discussion, because we were British subjects and Australian citizens at the same time between 1949 and 1987, and there were British subjects who were not Australian citizens who are still to this very day on our electoral roll and have voting rights, even though they're not formal citizens, because the court recognised they could not be taken off the electoral roll. And that was part of the discussion as to why, for a particular period, the High Court said they are full members, they are non-citizen, non-aliens. But then, by evolution of a court and the way different interpretations occurred, they determined no, even though someone might be on the electoral roll and voting, they might possibly be available for removal. But in relation to equal treatment, we've never seen an equality of treatment in relation to citizenship in Australia. And in relation to this decision, and this is relevant to my work in the 50/50 by 2030 Foundation, which also seeps into gender as well. If you apply the same laws to everyone as if they were the same, then you are going to have a differential outcome, because the reality is our lived experiences are very different. And the idea of equality is not just formal equality, it is about substantive equality. And I think that the majority judgment in the court in responding to the minority statements that were concerned about that as an outcome of a decision like this, of Indigenous Australians getting special treatment in being identified as non-citizen, non-alien, was actually saying, no, we have to recognise that within our nation as a whole, the Indigenous people have that first continuing connection. That does mean we have to think about how these laws play out against them through their different experience compared to all of us who are not Indigenous as migrants to Australia. And that differentiation, as we can all appreciate, is quite significant when you think about membership. I would then, just finally go on to say, if anything, we should be revisiting the notion of those members of Australia who have lived all their lives in Australia, who, for whatever reason, didn't formally take out citizenship, but happened to hold another formal citizenship. We have what I would say, in terms of that moral compass as well, a very concerning period where Australians in all but law, and I write about this in my book, they are Australians in all but law are being removed to countries that they have no association with other than a formal citizenship certificate, because we can remove them. It does hail back to our origins as a penal colony where the executive decides to remove criminals who they can, rather than recognising their true connection to community. Can I just add one thing, and perhaps, Senator Stoker, you may remember my answer to this, and I think you might have asked me this directly before the other committee. I do think in that one scenario that I believe would lead to the loss of citizenship is if you sought to get rid of the nation state itself, because of course citizenship is membership in a formal sense of that nation state. So that the original provision in the Citizenship Act that if you took up arms for with a country that was seeking to get rid of Australia, at war to effectively overtake that country, well then that would be the one action that I could identify as a matter of philosophical consistency with membership of the nation state. If you're seeking to get rid of that nation state, then that would be an action that could lead to the loss of citizenship. But I think if anything else comes down to your values beyond the end of the nation state, as opposed to acting inconsistent with what we determine our Australian values, that is the slippery slope that we're talking about, where the executive takes on too much power in relation to citizenship. And the way I've articulated is that the move to the naming of citizenship as a status as opposed to being a subject was that move towards that there really shouldn't be the power of the state to remove citizenship, save for that one scenario. Because once you start playing around with the basis of determining someone's actions as reflecting inconsistent values with Australia, you're going back to the notion of being subject to the power of the state, being subjects in a way that is undermining of an equality of citizenship.
Thank you very much. In terms of the...
Probably be a collective response around the room, but to say that the High Court's decision stands is a statement that we all know is until there is another judgment that is the law that everyone should observe and follow. And if there is any desire to change or alter it, one can argue before the court. That's what's so wonderful about a High Court as an institution. It stands on its reasoning. That's why it's such a fundamental rule of law notion that is totally accountable, because we can understand its reasoning and we use that to guide us in the way we act.
Thank you. So, Professor Rubenstein.
There are a few hands that have gone up, but I just thought that one way of making a practical suggestion at the end of the day, drawing in some of the themes that have come out of the day and coming back to the Constitution, which was our starting point, is to pick up on a theme of Professor Irving's of thinking about constitutions not only as a constraint on excessive power, but also as an enabler to reinforce the changed notion of Australian identity. And the very first term of reference is, what do we need to do in terms of the changing notions of nationhood, citizenship and modern notions of the nation state in the 21st century? I think we need to call upon our leadership for a bipartisan recognition of the need to update our constitution to better reflect that national identity. And there are three areas, and this is where the Republic does come in, that I do think that we should have a commitment to work as a nation towards resolving and better reflecting our current society. One picks up beautifully from Ms. Lim's recognition of the multicultural Australia we have. A completely different story could have been told about the Section 44(1) debacle. That story could have been of the success of our multicultural nation, that so soon after migration occurs, we have an active citizenry, a sense of commitment and connection to wanting to be in this parliament. That was the real story behind what is going on, and we need to change our constitution to reflect that success story of our active citizenry. So Section 44 desperately needs change, and we have further cases in the courts this month that may give rise again to that need to see how that practically plays out. The second is, of course, in relation to our relationship with our Indigenous people. The Uluru Statement is a very profound statement, as many in this room affirm. But the bottom line is, and the High Court's decision last week, is recognising we need to change our constitution to better reflect that reality. And then the third, this is a nice set of three issues that would reflect a changed and affirmed notion of our positive community, is our independence as a nation state for a change to a republic.
Thank you very much. Yes.